Sri Navaneethakrishnan, please adhere to time.
Yes.
Yeah.
Thank you, Deputy Chairman, sir. I deem it a great privilege to stand before this August House to speak on the Constitution 121st Amendment Bill 2014, Bill number 97 of 2014. I thank the Honorable Law Minister for referring to the letter written by Honorable Chief Minister Amma regarding this bill. No more collegium system thanks to central government. Collegium system of appointment of judges is against the concept of rule of law. Honorable Chief Minister Amma recommended that Judicial Appointments Commission should function at two levels, at the national level and at the state level. That is contained in the letter written to the Honorable Law Minister. The National Judicial Appointments Commission for Supreme Court judges and the State Judicial Appointment Commission is for the High Court judges. Now, Article 214 as well as Article 217 are amended by this constitutional amendment. The 124 deals with appointment of Supreme Court judges. Article 217 deals with appointment of High Court judges. Now, as per this constitutional amendment, the central government role is protected because it was taken away by the collegium system. Now, my grievance is that the state government role must be again restored by including an amendment to create the state level judicial appointment commission. That is my humble submission because that has been very vehemently recommended. Strongly, it was suggested by our leader Amma in her letter to the Law Minister. So because the state government is in a position to locate or point out the right candidates from the depressed classes, because by minorities, women, backward classes, scheduled caste, scheduled tribes. And also, in our state, the Honorable Chief Minister Rama is implementing the 69% of reservation policy, that too in the judicial appointments also. Because through State Public Service Commission and also the district judges are selected by the High Court, all judicial appointments are following the 69% reservation. So now because of this reservation, scheduled caste, scheduled tribe, backward class and most backward class candidates are able to occupy the judicial post at the state judiciary level. It is a well-known fact that the High Court judges post and the Supreme Court judges post are not available to the Mofussil practitioners of law and also not available to the common man. Now, because of the effective implementation of the 69% reservation policy by Honorable Chief Minister Amma, now the 69% reserved community people are occupying the judicial post in the state of Tamil Nadu. So now, out of 24 high courts, the total strength is 906 judges posts are available. Out of 906 posts, one third of the total strength of the post is filled up by the judicial officers. That is, the officers they are holding in the subordinate judiciary. So the 1/3 of the strength must be filled up by the subordinate judiciary. That guarantee must be given by our Honorable Law Minister by way of amending the Constitution itself. Because then only the already judicially trained people can occupy the posts of High Court judges, and also that from High Court they can go to the Supreme Court. The Honorable Chief Minister Amma is very strictly following the reservation policy to uplift the downtrodden. That is why I am stressing again and again at the risk of repetition. And also, the Article 2 in the Article 217 of the Constitution, the consultation is only with the Chief Justice of India and the Governor. In this contest, our Honorable Law Minister will know better than me that Governor means the Council of Ministers. The advice offered by the Council of Ministers is to be forwarded by the governor to the president. So, the role of the state government must be protected. This is my humble request at the risk of repetition to the Honorable Law Minister. I had the privilege of assisting our Honorable Chief Minister in one of the cases, hence I am taking the privilege. Again, I request him that the role of the state government must be restored, preserved
No, guys.
in the process of selection of High Court judges. In the state level Judicial Appointments Commission, the Honorable Chief Minister must be included as one of the members of this commission, and the views of the Chief Minister must bind the commission. So it must be given due weightage. So because state government is accountable to the people, answerable to the people. So it is the state government is in a better position to identify the right candidates. This is my humble request. And also the downtrodden people can come to occupy the higher posts of High Court judges and the Supreme Court judges. This is my humble submission. And also,
One more minute. Only 1 more minute.
yes, our Honorable Chief Minister is more judicious in her action and thought. She is more judicious than any other judicial institution of our nation. So because of her, many lawyers from the rural area is now practicing in the High Court of Madras. She has given the appointments very liberally. That is why I request the Honorable Law Minister to include in the constitutional amendment creating the state level Judicial Appointments Commission. Thank you, sir.
Thank you very much.